with us this evening. So looks like it's small enough that whoever would like to speak and ask questions has the floor. And Mr. Rossetti, you had mentioned that you'd like to talk, so.
Up at the microphone?
Sure.
Okay.
I was shielded by the rain.
Do I need to introduce myself, or is it? This is casual, right? Okay.
But however, we are being videoed, so it probably would be good to state the
Ruth
record.
Rossetti, 215 Dr. Jack Road, Port Deposit. What I wanted to do is follow up on some of the comments I made at the last Citizens Corner about the tiers maps. I know it's not on your agenda tonight, but I did want to follow up a little bit. To start with, on the one that's labelled Maryland Department of Planning version, that's the tiers map 6. I urged you at the time to check with MDP and see whether they took ownership of that map, and I wonder whether anything had come from that.
Eric, do you have any update? We checked with MDP on that. Rupert's questions were that there were aspects of the map.
Map 6.
Was it map 6?
Yeah, map 6.
That were not consistent with was with our own comprehensive plan?
No.
With the
MDE's buy-in.
MDE or
MDE, Maryland Department of Planning. P.
Well, they have made comments on draft map 4, which is the one that the commissioners took to public hearing on September 4th. So that was the one they met with you in the Perryville room, which was near the end of August, and that was the one that they provided comments on as part of their critique of that map. Draft map 6, which is commonly referred to as the MDP map, is the map that David put together using information on MDP's website and interpreting that into a map. But it is not the map that they made correctly. They have not made a map as far as I know, which is canon.
Has Maryland Department of Planning looked at map 6 or any other map other than map 4?
The only map I know that they've looked at is map 4, which is the one they made comment to us at that meeting in the Perryville room back in August.
They made some comments in that audio from that meeting, and I followed up with David Dahlstrom, and he said map 6 isn't MDP's preferred future for Cecil County. The map wasn't produced by us and doesn't conform to SB 236 or our technical guide. So I don't think they have any ownership in map 6. And I know it sort of comes across as that's the one that they would like to see us turn into. I don't think they would say that. The second thing was on some of the testimony at the public hearing, there were an awful lot of very strong concerns expressed. And I wonder if some of them were actually based on fact. I'll give you an example of one of the things that I heard. Actually, I read it in the press before that meeting, and then it was mentioned during the meeting that farmers would not be able to start on-farm businesses because of SB 236, and that I think is not correct. SB 236 does not affect anything other than the residential component. Mm-hmm. So there were some people, certainly in the tractor rally and the area there, the reports in there were talking about unable to do on-farm businesses, and I don't think that's a correct understanding of what SB 236 is going to do. And the second area would be, actually it was something that was quoted in the press between, it was a question Commissioner Hodge, you asked Director Sandstrom, and he answered with in the SAR, 1,000-acre property would be limited to 5 lots.
No, it was my question was the NAR.
In the NAR?
Yes.
Okay. It came across, I think it was in the press, it showed up as SAR. But
it could have, but I'm almost certain my question was NAR.
Okay. Regardless of that, there are only 5,000-acre lots in the county, 1,000-acre parcels in the county, and all of those are up in the NAR, and they're all either owned by the state as park is, are we talking about parcels or properties? And SB 236 is directed at parcels rather than properties. And so, looking at that, it sort of has a different flavour to it. If you're thinking about a 1,000-acre parcel, there aren't that many of them. In fact, there are only 6 parcels, but there are only 12 parcels greater than 500 acres in the entire county. And the more important probably is that the area that Tier 4 does prevent major subdivisions, more than 5 new houses per land parcel. But that means that a parcel less than 59 acres in the NAR and 119 acres in the SAR are not affected by SB 236. An awful lot of the people who came up and spoke, one person said, you know, I've got 80 acres on one side of the street and 30 acres on the other side of the street, and I'm not going to be able to develop or to do anything with those properties. And I don't think that's correct. And it's almost as if she was unnecessarily worried by what she had heard, and it wasn't. I think she was unnecessarily worried, and I wondered whether you had any plans to try and allay those fears. I.e., you sent out a letter before the hearing to all the affected landowners. Having heard the testimony, are you thinking about sending out a letter that says, oh, by the way, you know, we heard a lot of testimony. Some of it was not on point, or you are unnecessarily worried. Can we address that? So that would be a question that I would have: is how do we allay that fear, and what's the best way of doing it? Because I haven't seen anything that corrects that.
The original letter that was sent out from planning and zoning, we made Eric did the original draft, and we tweaked it just a little bit, and every effort was made to make it non-political and to not raise their concerns, but simply say, you may be affected by this, and we encourage you. Here's a link to the map. Or actually, I think a map was included in the envelope, wasn't it, Eric?
Yes.
Yeah, in the map.
And then additional information could be viewed by going to the county's link. And just people were encouraged to look at it themselves, and then it would appear that, and I'm sure some of them they all came to their own conclusions, whether they were correct or not.
Okay.
Your point's very well taken.
Very good.
But Rupert, I'd like to say one thing. There were lots of people that came that had already sold their preservation or eased their preservation that spoke out against this too. So not everyone in this room that was speaking was actually impacted. I think that several of the speakers were concerned about others and the impact on others. And in general, the impact that it could have on other property owners, not just themselves. So some people were just speaking generally and broadly. As far as allaying people's fears, I think that the commissioners need to make a decision on which direction they're heading, what map they're going to propose, what they're going to do next, and then potentially notify the public and have another hearing. I think last week, before we had our public comment period, 3 commissioners said, if we're going to revise the map substantially in any direction at all, we should have another public hearing. So I'm not sure if we're going to have another public hearing. It depends on what that map looks like. But we certainly owe the citizens some explanation of what we're doing.
Okay, good. But as regards that, what the last I read in the press, and I haven't been to any of your meetings today, was that you were planning to consider fighting SB 236. And so, I'm picking up stuff on the press, but I would urge you to look at, if you're not successful in that you look at alternatives that we can do, and since we will have to live with it. And a couple of those alternatives would be, as several other counties have already done, is you can adjust the limit on minor subdivisions. And several counties, Carroll has gone from 3 to 7, and so on and so forth. A second area is that apparently, as I understand it, that there's a question about interfamily transfers and whether they're included in subdivision or not included in subdivision. And some counties have a means by which they keep interfamily transfers out of the subdivision process. I think there's an expression they use. Let me see if I can find the notes. That is off conveyances, and they are not platted. They're created by deeds that are not technically subdivision lots. And the comment I got back from MDP was that SB 236 defines a subdivision's division of a tract of land or parcel of land into at least 2 lots for the immediate or future purpose of sale or business development. Since there are many definitions of interfamily transfers and similar situations at the local level, the local county attorney might want to seek guidance on this issue from MDP's principal counsel, Amanda Conn. So I think there's the, are you going to try and contest SB 236? Even if you are, we ought to be thinking about ways that we can live with it if we have to. And so these are a couple of the areas that I think would be sensible for us to be thinking about.
Eric, are you familiar with the different options available with inter-family transfers? And how that, do we have anything currently in Cecil County code or ordinances that allows that to happen? Because what we're talking about, if I understood it correctly, if they don't deed it, it's not created by deed but by plat? The transfer of property?
Yeah, it's called an off conveyance. But it seems like it's worthwhile us pursuing avenues where we can allay the fears of some of the other landowners about being able to subdivide for their children and their grandchildren. There appear to be some tools that we can take advantage of. And that's really what I wanted to come and talk to you about. I can send you all my typewritten stuff later. Didn't want to make copies for everybody because I wasn't sure how many trees I had to cut down.
I'd like to agree with you on the back, but I think it's fruitless for us to fight SB 236 in court. From all professional legal advice that I've received from multiple sources, SB 236 was an adopted legal law statute that we have to comply with. And I think that the consequences for not doing a map or some compliance is too extreme to ignore it. And I think that we the commissioners should provide a map to the state. I think if we put all our eggs in the basket of, well, let's fight the bill and lose, the consequences are pretty significant and not worth the risk. So even if we choose to take other action, and personally I think the other action is basically really showing our displeasure with all of the total initiatives of the governor at this point in time, in this time in the economy and so forth and so on. Too much too fast. But generally, I think it's a big mistake not to comply with the law, and so I think we need to put some map in their possession for them to review.
And what you probably read in the newspaper was a statement by Commissioner Dunn that said, let's fight the state on this and not turn in a map. And we had some discussion on that, and there was no agreement to not turn in a map. There was an agreement that we would meet with the Rural County Coalition, which was supposed to take place tomorrow, but it's been postponed to a later date, to discuss with other rural counties what conclusions are coming to as they're doing their tier maps, as well as other issues as a result of Senate Bill 236. So there's this agreement, let's talk to the counties and put our heads together and see how we can best manage this while we protect our local planning ability and property rights of our individuals, but yet still, work with what the state is giving us in terms of requirements. There wasn't an agreement to sue the state either. But however, we'll see how this goes. And I would agree with Commissioner Hodge. I've done some homework too. I talked to the Maryland, or Wayne Stafford with Cecil County Farm Bureau. And about what happened after Senate Bill 236 was passed was the Maryland Farm Bureau did seek legal counsel and was advised that the wording of 236 was loose enough that if there was a lawsuit, it probably would not prevail. And I've talked to a couple other county commissioners in other jurisdictions who have also consulted with attorneys who said, the language, there really has to have something happen where somebody's denied something, whether that be a county or an individual property owner or developer, etc. They have to be denied something before a lawsuit, grounds for a lawsuit would kick in. So that's what I've been hearing. I don't know what specifically Commissioner Hodge has heard in terms of when he's been doing his research. But I think it's important for us to, for all the counties to put their heads together and say, what's the best approach on this? I mean, we clearly, you elected us to obey the laws, and we recognize that. At the same time, if there's a reason that a law is going to hurt the citizens of our county, then I think we need to stand up and explain to the state why and say, we need to work this out. So I hope that clarifies what you read in the media and the continuing discussion with that. And we're, at this point in time, we have not made a decision as a board of commissioners about what direction to pursue.
Thank you. Yeah, the only other place I would look at, sounds as if Harford County has pulled off a map that they're sending down that shows tier 4 for a lot of their area under 1 to 10 density. And if they figured out how to do that, that would be wonderful to learn, because that would solve a lot of our problems.
Well, hopefully I'm going to see David Craig tomorrow. I have a NACO meeting in Annapolis, and I'd like to have a chance to talk to him. Interestingly enough, Harvard's process has been very different than ours in terms of the public and communicating with the public on what's going on, and even their staff, from what I understand, is not giving very many answers to the public, and I don't know why. I don't want to pass judgment on that, but or speculate. But there is a map. I've seen it, and it's pretty green.
It is.
I happened to talk to David Craig this afternoon, and it was a concept map. It is not for public hearing or comment, really. It's something that they're going to provide to their the planning staff. Oh, he was going to present it to the council. That's what he said he was going to do. He was going to have a workshop, even though the council doesn't have the authority to approve it or reject it. But he wanted to have a work session to submit it to the council just for their knowledge. I guess the point is that originally they weren't planning on having public hearings for public announcement other than posting it on their website. So that, in his mind, that's not a done deal, a finished product.
Well, it is on the website.
Yes.
Mm-hmm.
Yes, it is on the website, but it hasn't been promoted or
Or approved. Okay.
And like I said, he's going to have a work session with the council.
Did he tell you when the council's going to be looking at?
No, I didn't.
Okay.
Yes.
Well, thank you for your time.
Thank you. Would anybody else like to ask a question or share a comment?
Alreasin, 632 Conway Road, Conway. There seems to be an awful lot of confusion about the minor subdivisions. Could someone clarify, the press is here now, what the minor subdivisions entail? In other words, let's say I have 50 acres. My understanding would be that under the comprehensive plan, I could only divide that up in 10-acre plots as it is.
Depending on the zone that you're in.
Assuming it's in
You're in NAR.
that's where I live.
Right. In NAR, it's 10 acres.
Right. And basically this law then would come in and say I would be limited to 5. So regardless of the size of my property, it would appear 1,000 acres may not be a logical thing. But right now I have 25 acres, so the way that I look at it, I have a house on it, so I could only cut it in half. If I had sufficient to divide it into 5 plots, I would have to have greater than 50 acres. Now, if I had 100 acres, would I be limited again to 5? So only 50 acres could be set aside in a minor subdivision. Is that a correct statement?
I'm going to defer to the expert.
Excuse me, minor subdivisions, or the main difference between a minor subdivision, well, several differences between a minor subdivision and a major subdivision. One is the density issue. Major subdivisions, to use the example of the Northern Agricultural Residential Zoning District, can only occur at 1 unit per 10 acre density. Minor subdivisions can occur at 1 unit per 1 acre. A minor subdivision is defined as a total of 5 lots, 4 new lots, with the 5th being the balance of the property. County started tracking minor subdivision eligibility on April 15, 1976, when the first subdivision regulations were adopted. So if an individual has not subdivided his or her property from that time, they would have full minor subdivision eligibility. If the property has been subdivided, then they may or may not have minor subdivision eligibility based upon how many lots came off the parcel as it existed on April 15, 1976. Another difference is that minor subdivisions are reviewed administratively by our Office of Public Works and the Health Department. Major subdivisions go through the public hearing process and get reviewed by the Technical Advisory Committee as well as the Planning Commission. The Planning Commission has 3 steps to it, which is a concept plat, preliminary plat, and final plat. Once the final plat approval is received, then the plat is signed by us, Health Department and Public Works, and it can be recorded in the clerk's office. At that point, you have lots that can be sold.
I think I heard you say that you could have 1 acre plots, 5, 1
Now,
acre.
the minimum lot size is 20,000 square feet. There's a difference between density and lot size. Density tells you how many lots you can potentially create from the gross acreage of a parcel, but they don't have to be 10-acre lots. In the case of an NAR subdivision, you can have as small as, if you're on well and septic, 20,000 square foot lots.
When you say density, are you talking about the overall density of the NAR? I'm missing.
No, what you do is you look at, again, they use, if you're in the Northern Agricultural Residential Zone, and if you have a 100-acre piece of property, and you wanted to do a major subdivision, based on the 1 unit per 10 acre density, you could potentially create 10 lots out of that 100-acre piece of property.
If I'm doing a minor.
Could 9 of those lots be 1 acre lots?
Yeah, you could have 9 20,000 square foot lots, and then one large lot that's the balance of the property. If you want.
But if that same 100-acre parcel was in Tier 4, the maximum is 5.
Yeah, if it winds up in Tier 4, then you won't be able to do major subdivisions anymore. You'd be limited to minors, and if you don't have any minor subdivision eligibility left, you wouldn't be able to do any subdivision.
Well, that's what it comes down to. We've been discussing Tier 4, so I'd like to concentrate on Tier 4. I'm in Tier 4, okay? 25 acres, what can I do?
What's your base zoning district? Do you know?
My what?
NAR.
NAR.
Well, if you still have minor subdivision eligibility on your property.
Let's assume that I do,
That
just to
you
make
do.
it simple.
All right, if you have full minor subdivision eligibility and you're in Tier 4, say the map is adopted and it's in effect, then at that point you have the potential to create 5 lots.
And that's where it gets confusing, because we talk about NAR being 1 to 10, SAR being 1 to 20.
For major subdivisions, which you won't be able to do anymore if you're in a Tier 4.
I guess if I was doing it, when I was a manager, I laid out what ifs. If I have this, if I have that, what I can do. And I don't know how convoluted that would be, but it would certainly clear the air, because I'm quite sure, and I've been looking at this from day one, trying to figure it out, and I haven't figured it out yet. So I'm quite sure that the people who are stumbling on it through a letter haven't figured it out at all. Thank you.
Is there anybody else that has a question or would like to have a comment from some commissioners?
Ed Cairns, 104 Jackson Hole School Road. I didn't come prepared to talk, but I would like to express an opinion to you for guidance. Senate bill does an excellent job of protecting farmland from residential development. It's not perfect and it has some disadvantages to Cecil County. But on the other hand, nothing's ever perfect. You know, no rules or anything ever resolve everybody's needs or everybody's help. And my feeling is that to protect farmland is so important, we don't want to lose that opportunity. Whatever we do to try to correct Senate Bill 236, don't give away the power to protect farmland from residential development. And along this line, another thing that would protect farmland in Cecil County is to get public water and sewer in the I-95 Route 40 corridor. And that's something I'd like to see the commissioners do everything they can within their powers to encourage and get done. That's my only comment. I don't know if you have any questions on that.
No, but I do agree with you that there's no more of a silver bullet to solve our growth management issues, our taxing issues, our sprawl issues, protecting farmland issues, than infrastructure.
Yeah.
That is the closest thing that we have to a silver bullet, in my mind, to solving many of the problems that we're going to face in the future. And we should be, it should be a priority of what we do every day as commissioners, and hopefully the county executive will be working on it with as much effort as they can.
Well, we've missed a few opportunities on that, and I hate to see us miss any more.
Agreed.
Thank you.
I didn't really come prepared, but listening to all the comments. When I think about this SB 236, it's a little convoluted when it starts applying to Cecil County, because we got NAR 1 to 10, SAR 1 to 20. The way I understand this 2-4 is if we were to put just the SAR into Tier 4, then the SAR owners would be allowed to develop their land at 1 to 20, because there's a special clause in SB 236 which says if you do a yield calculation on Tier 4 and it comes out 1 to 20, then the land in there, and in case of SAR, it's owned 1 to 20, should be able to be developed at 1 to 20 with a major subdivision. So if somebody had 200 acres, they should be able to put 10 lots on it. But then the state encourages you to put all ag land into Tier 4, so as soon as you put NAR into Tier 4 and SAR into Tier 4, and you do the calculation, you get, I'm not sure if I'm right here, you get like 13.7 yield. And now that's below the 1 to 20, and so you can't develop any of the land as a major subdivision, because even at 1 to 20, because of the stupid yield calculation. But Cecil County is a little convoluted because it has ag land zoned 2 different densities. So I'm not predicting what's going to happen, but I can see if unless the state yields to allow you to do 1 to 10 in Tier 4, I can see the SAR land ending up in Tier 4 and the NAR land ending up in Tier 3, so NAR can be developed at 1 to 10 and SAR can be developed 1 to 20.
That's a possibility. Eric, would you like to comment?
I don't know if all that.
I mean, yeah, if just for clarification for me too, because Ron, you sent us those comments. I remember reading that.
I sent you the comments,
yeah.
and I repeat them. I wasn't planning, and I just showed up.
Well,
And
and
it's on my mind, and it's like, does the state understand the special situation that Cecil County's in because of the way they've done at two different farmland densities.
Well, before Eric starts, I do think they do understand, and I think that they want Cecil County to have 1 in 20 density on the northern and the southern. I think that they've been encouraging that. That they would like us to, they would prefer us to go with 1 in 20 in the northern area. There's no doubt in my mind, and this is kind of one of the ways that they can push it to happen. Now, Eric can finish that, but my understanding of the density yield doesn't matter what's in Tier 4. I think that we've crossed the path with density yield a long time ago because if you take out the preserved areas and the state-owned land, we're already past that 1 in 20 already, so there's no way that additional major subdivisions can be done in Tier 4.
Even if you just put SAR land in Tier 4?
What Mr. Harmon is referring to is the section of Senate Bill 236 that says if you ask the state for a yield analysis of your Tier 4 and it results in 1 to 20 or 1 to 21 or 1 to 30 or 1 to 50 as the case may be, you would still be able to do major subdivisions.
You can ask for exemption.
Yeah, well, that's what I'm saying, yeah. You ask them to do the yield calculation of your Tier 4. The area that they look at as far as Tier 4 is countywide. They don't just segment one portion of it or another. Also, they have stated that they will not count in the acreage any preserved lands or publicly owned lands that would be backed out. So you're dealing with a situation where if those lands were included, it would help your calculation, obviously, but they're not. Plus, they are already counting previously subdivided property. So the analysis that we have done under a couple of different maps of the drafts that have come out, the best so far that we've been able to achieve is a 1 unit per, I think it was 14.57 acre density in the Tier 4, which obviously exceeds the 1 to 20 exemption.
Even if, let me ask you a question, Eric, even if you just put SAR land in Tier 4, it doesn't come out as a calculation of 1 to 20?
No, the density is a separate issue in this case. What you're looking at is the acreage that you have within that Tier 4 area, and I understand what you're saying, and you're backing out all the protected lands that are already in there.
Yeah.
So your pool is getting smaller, and then you're including everything that has already been subdivided, which until 1993 was 1 to 1 in the AR zone areas, and then became 1 to 5 and 1 to 8 in the south. And then become recently 1 to 20. So you have all that included in your calculation. So
old SAR land.
Everything that
put into Tier 4.
Everything that's been subdivided.
The higher density,
Right.
Then brings it down from 1 to 20.
Right.
I was thinking that we're just talking about, why the hell? These state people, they drive me nuts. They're illogical. And their density calculations, somebody needs to be talked to.
I think this was intentional.
Absolutely.
This was intentional.
And we had a chance to talk to Secretary Hall
Old
a couple
stuff.
months ago.
Yeah.
Why does that have anything to do with people? We're only talking about folks who have land that's undeveloped, that's put into SAR, put into Tier 4. The others is done and over with.
But that's in the formulation and the calculation.
Well, I understand, but it's, well, I won't use the words I want to use. That's all.
Thank you, Mr. Harmon.
It's true.
Hi,
Valerie Falcioni, Northeast. Yeah, it's been interesting going through all this tier mapping and the SB, bill, and it just all boils down to the rural counties are getting stiffed, and it's intentional. It's a power, it's a power play, and I really would like to see Cecil County and all the other rural counties bind together and fight think what is happening is unconstitutional, and there's got to be legal ways to have this bill be declared unconstitutional. It's an executive order by our dear governor, and you know, he wants to be King O'Malley here. I'm just, you know, it's like one thing after another, and it isn't going to end here. You know, I read the whole document. I read Plan Maryland, so I was easily predicting that all of this would happen when it finally came out. You know, so none of it surprised me, and it will not surprise me if we get further shaft. You know, this is only the beginning. You know, look what they're doing to our bridges. You know, they're just trying to shut us down altogether. They want Cecil County to be open land. You know, and when I looked at the maps, you know, of what the future is, there was more open space in those maps than there is presently now. So what does that tell you? They want to systematically move people out of the country and live on top of each other in the Tier 1 areas. And this is what it's all about. And we have got to fight it.
Valerie, I'll share with you a few things that some of the things have been very obvious and other things a lot more subtle. But as I've spent time in Annapolis and across the state talking to other counties and listening to legislators and other elected officials talk about the woes of Baltimore, the Baltimore area, I recently learned that Baltimore lost 1/3 of their population and 1/3 of their jobs, which takes away from their tax base, and they have a failing infrastructure. Their schools have endured a lot of criticism for their quality, and there's a lot of crime as well, and so it's no wonder that people have been moving out. But the result of that is that they don't have the resources that they need. They're, in my humble opinion, they're being very blatant about saying we want to encourage as many people to move back into the city as possible. My personal opinion is that Plan Maryland, all the septic legislation, Senate Bill 236, that, you know, all of these things put together, and this is just the tip of the iceberg. You're right. I mean, there's so many other things. Our watershed implementation plan. There's a lot of different elements as part of this. I believe is basically doing forest preservation and making it so expensive to live outside of the city, and either that or the regulatory burdens are so burdensome that people will choose to live in the city because of that. However, there's an irony or a flaw in that rationale. And the rationale is you can't force people to choose where they want to live. I mean, that's still a choice. People may choose to downsize their home, but if they want to live in the country, they're going to live in the country. So I feel like there's a flawed reasoning there. I'm not sure my personal opinion and that explanation of it will carry any weight at all in Annapolis, but you know, when I step back from, you know, the day-to-day fight or month-to-month fight or whatever it ends up being, that's what I see. That's what I see out there. The other thing is that, and I can't remember who mentioned it, the decisions that are made in Annapolis, and many times they have no concept how it affects us here in Cecil County. Just absolutely none. And in some cases they don't care. And that's why it's our job to make sure that they understand that. And you know, that's what we're trying to do. Before you came in, you had asked about the lawsuit and, you know, suing the county and working with other rural counties as well. We were supposed to have a meeting tomorrow, and that's been postponed with the Rural Counties Coalition. There has been some dialogue with folks who have sought legal advice about are there grounds to sue and when. And at this point in time, the way Plan Maryland is worded, the way Senate Bill 236 is worded, the legal folks out there say there's not grounds there to sue and win. Something has to happen where somebody's denied their ability to develop or denied the ability to do something before that actually kicks in. But we're examining it. We are working with the other counties, and you know, we need to fight this together.
Thank you.
No, I certainly agree with Terry. I know that I listened to the State of the City address by the mayor of Baltimore, and one of her goals, one of her objectives is to increase the population in the city. The problem is, I think they're going about it the wrong way. They need to make the city more attractive. They need to reduce the crime in the city. They need to improve the public education in the city. They need to lower the taxes in the city. And through incentives, what I'll call the carrots, people might consider moving back into the city. But right now, there's more people moving out than moving in, and it creates this dilemma that I think, as you remember, the governor of Maryland used to be the Baltimore city mayor. And so, you know, he has a background that he's trying to support the city of Baltimore. And I think it's against the wishes of the people that live in Cecil County and other rural counties.
Well, he is taking a tack that is really diametrically opposite to what has been traditional, like you say. If the city is a mess, fix it. You know, don't be going outside of the city, taking other people's money. And I mean, Baltimore is a bottomless pit. It always has been, as long as I've lived in Maryland. And it seems like, you know, between William Donald Schaefer and Mr. O'Malley, you know, whenever we get a Baltimore mayor being governor, we get treated like the outhouse. So, but yeah, you know, it's just I don't like the state telling the locals how to do their local business because they don't know us. Period.
I feel your pain.
Thank you.
Do you mind if I make a comment?
Sure.
I was down in Annapolis during the session this year, and I was talking with Baltimore County Councilman about a different topic, but I also brought up the Senate Bill 236 issue. And his comment to me was, I'm in Baltimore County. It has no effect on me. I haven't even read the bill, but I'm going to vote for it. I was like, well, you don't understand. And he says, it doesn't matter. It doesn't affect us.
Yeah.
He said, so why not support the governor on this one? And that's unfortunately the problem we have.
You should read the bill.
I understand, but
Thank you.
Thank you. Is there anybody else that has a question or would like to make a comment? Okay, we will adjourn Citizens Corner for this evening. Thank you so much for coming, and we'll start our regular